Check this one and this one. And I use some.
See him. Goodness.
Ready to roll.
Yeah. Okay, I'm going to call the meeting to order. October 9th, 2017, 4 o'clock. Roll call, please.
Mayor Crawford.
Here.
Commissioner Blanchard.
Here.
Commissioner Davis.
Here.
Commissioner Hodges.
Here.
And Commissioner Ryan.
Here.
Okay, if you'll all stand for the Pledge of Allegiance and a moment of silence. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Okay, we're on item number 3, awards and proclamations.
Item 3.1, the week of October 8th through 14th, 2017, is Fire Prevention Week in the city of Salina. Troy Long, Fire Marshal, will read the proclamation.
Hi,
I'm not
Chief.
Troy, but Troy's here.
Hi, Troy. Hi, Chief.
Good afternoon, Madam Mayor and Commissioner. Before I do the proclamation, just want to have a few comments here. You know, it's not a coincidence you don't read a lot, or any, hardly, of any structure fires, commercial or residential, here in Salina. There's a reason for that. And the reason is not only these gentlemen, which Inspector Jeff Daly and Inspector Joe Kovacic, Fire Marshal Troy Long, it's also due to the fact that there's 84 other members of the department that can teach fire safety, that can teach prevention, and do a wonderful job every day. A lot of people know us from our EMS history and our EMS reputation, but our structure firefighting reputation is, if not better, at least equal to that. And I'm very proud to be the chief of this department. We're extremely fortunate that you as a governing body support us in that, give us the resources that are available to do our job safely every day. And we thank you for your continued support. To cap off Fire Prevention Week this week, Sunday, we'll be having the 12th annual Guns and Hoses charity football game. Invite you all out if it's not raining, where we'll participate against the police department for 2 very needy families that have been identified, and it's a very, very exceptional charity event. Been going on for 12 years now. It's at Kansas Wesleyan at 1 p.m. So with that, I'll turn it over to Fire Marshal Long.
Good afternoon. I'm just going to read the proclamation. Whereas the city of Salina, Kansas is committed to ensuring the safety and security of all those living and visiting Salina, and whereas U.S. fire departments responded to 365,500 home fires in 2015, according to the National Fire Protection Association, or NFPA. And whereas U.S. home fires resulted in 2,560 civilian deaths in 2015, representing the majority of 78% of all U.S. fire deaths. And whereas new homes are built with lightweight construction materials, that burn faster than older home construction. And whereas many of today's products and furnishings produce toxic gases and smoke when burned, making it impossible to see and breathe within moments. And whereas these conditions contribute to a small window of time for people to escape a home fire safely, with people having as little as 1 or 2 minutes to escape from the time the smoke alarm sounds. And whereas a home fire escape plan provides the skill set and know-how to quickly and safely escape home fire situations, and whereas a home fire escape plan includes 2 exits from every room in the home, a path to the outside from each exit, smoke alarms in all required locations, and a meeting place outside where everyone in the home will meet upon exiting. And whereas home fire escape plans should be developed by all members of the household, and whereas practicing a home fire escape plan twice a year ensures that everyone in the household knows what to do in a real fire situation. Whereas Salina's first responders are dedicated to reducing the occurrence of home fires and home fire injuries through prevention and protection education. And whereas Salina residents are responsive to public education measures and are able to take personal steps to increase their safety from fire, especially in their homes. And whereas the 2017 Fire Prevention Week theme, "Every Second Counts," planned 2 ways out, effectively serves to educate the public about vital importance of developing home fire escape plans with all members of the household and practicing it twice a year. Therefore, I, K. Crawford, Mayor of the City of Salina, do hereby proclaim October 8th through the 14th, 2017 as Fire Prevention Week throughout this community. I urge all people of Salina to find, develop a fire escape plan with all members of the household and practice it twice a year, and to participate in all the many public safety activities and efforts the Salina Fire and Emergency Service during this Fire Prevention Week 2017.
Thank you very much, and I want to bring to you the appreciation of the citizens of Salina for the work that you fellows do over there. It's people don't talk about it very often, but when something happens or they hear about the first responders in Salina, police and the fire, there's always gratitude. So thank you very much. And do you have any other activities that we heard about the football game?
We do. National Fire Protection Association has teamed up with Domino's Pizza to create a special Fire Prevention Week activity. On this Saturday, we have partnered with the new Domino's that went in over on Ohio Street. And the basics of it are when somebody calls to order a pizza for delivery, they're going to ask some very specific questions. When they answer the questions the way we want them to be answered, then we will go with a pizza delivery guy and deliver the pizza to the home. When we show up, if their smoke detectors are functioning, they get the pizza for free.
Hey, not a bad deal.
Yeah, I was going to say.
Everybody out there that's watching this on Access TV will know about this. So
Absolutely.
You'll be
And
busy.
they'll also be putting some fire safety flyers on the pizza boxes all this weekend. So.
Okay, good. Well, I have your proclamation for you, and once again, thank you. And you too, Chief. Okay, we're at Citizens Forum. If there's anyone here who would like to bring anything before the commission that is not on the agenda, this is the time to do it. Okay, we'll go on to, there are no public hearings or items scheduled for a certain time. Go on to consent agenda.
Item 6.1, approve the minutes of October 2nd, 2017.
I entertain a motion to approve the minutes of October 2nd, 2017.
So moved.
Second.
Have a motion and a second to approve the minutes of October 2nd, 2017. All those in favor say aye.
Aye.
Those opposed, same sign. Okay. Administration.
Item 7.1, first reading ordinance number 17-10898, amending Chapter 38, Article 1 of the Salina Code by adopting the 2017 Standard Traffic Ordinance. Item 7.1B, declare a compelling public purpose exists to allow first and second reading on the same day. And 7.1C, second reading ordinance number 17-10898.
Christina.
Good afternoon. I'm glad that you've started with the easiest one to present this afternoon. The city is asking the commission to adopt ordinance number 17-10898, which would be adopting the standard traffic ordinance for Kansas cities. And I did bring a copy of the 2017 booklet if anyone is interested in seeing that. It's probably more relevant when we talk about the Uniform Public Offense Code. The city has several standing local amendments to the standard traffic offense for Kansas cities, including Section 4, which expands the definition of authority of police, Section 33, which applies the maximum speed limits for the purposes of Salina, Kansas. Section 85, stopping, standing, or parking prohibited in specified places. And then Section 114.4, unlawful operation of a golf cart. The city has reviewed those and would like to keep those standing local amendments in place. The city would also ask to expand Section 85 to add subsection A14, which would prohibit stopping, standing, or parking a vehicle within a marked bicycle lane. That was at the request and after discussion by the traffic safety team that we felt that was an appropriate addition to make to STO 85. These city prosecutors also recommending that Section 30.2 be expanded. I don't know if the commission recalls, but last year when I asked to adopt the STO, the Kansas League of Municipalities had recommended that the penalty provision in STO 30.2 be removed. After conducting additional research and contacting individuals from the Kansas County and District Attorneys Association, it's my opinion that the penalty provision should be reinstated in STO 30.2. So that recommendation would be made by myself. Essentially, it would add a provision that states refusal of a preliminary breath test would be considered a traffic infraction, and they can be fined as such in Salina Municipal Court. Do you have any questions about the adoption of the STO?
Just
Any questions?
just on I guess section 133, it's referring to the lights on bicycles.
Yes, that was the only change
Am I
in
reading
addition to the seatbelt fine.
this incorrect? Is a lamp on the front no longer required by this, or am I just interpreting that incorrectly?
Between sunset and sunrise, it must be equipped on the rear with the
Rear.
red reflector or a lamp that emits a red light visible from 500 feet, or the operator must wear a device that emits a light visible from 500 feet. Previously, the law required that both a reflector and a red light visible from the rear and also a lamp on the front be required, but that lamp on the front,
The lamp on the front is no longer required.
right, as long as they are in compliance with the other requirements.
So how do you see them from the front?
Yeah.
Well,
That was going to be my
actually,
question, yes. Yeah.
It's the operator wearing the device, of course, would take care of that provision. And in considering that, I think that probably a headlamp is still going to be required. That's not very good language, wording the language, but that mirrors exactly the changes in the state statute.
Because if an automobile driver were backing up he or she wouldn't be able to see the bicycle coming towards them necessarily without the headlight.
Right. I think in interpretation,
Okay.
previously it was required to have both the reflector from the rear and a lamp on the front. The lamp on the front, as long as it's emitting that white light that's visible from 500 feet, would meet that requirement. If there's an absence on the rear.
I'm reading it, that section 133 is mainly addressing the reflector part of that.
That requires both, right.
What is the difference in a golf cart and a Segway or a wheelchair, motorized wheelchair, or those little things the kids ride around on that are the, electric glide surfboard things? And
I think a lot more swearing happens in a golf cart.
before the game or after?
My
the
amateur,
game?
yeah, during.
A golf cart is defined by the STO as a motor vehicle that has not less than 3 wheels in contact with the ground. An unladen weight of not more than 1,800 pounds, is designed to be and is operated at no more than 25 miles per hour, and is designed to carry not more than 4 persons, including the driver. But I think you might be more of an expert in this field because I think that you personally possess one. Is that correct?
Well, I do own one, and
It's
but I see
specifically-
people drive wheelchairs in the bicycle lanes, and I understand I can take a Segway in a bicycle lane. I don't know if that's true or not. Don't think so. So
I don't believe
there are a lot
that
of
is.
electric devices out there. I just wondered where this is going with it.
Right. And we have specific definitions for most of those things, including the golf cart. Obviously, we have a definition for what a vehicle is, what a motor vehicle is, what a golf cart is, but that is the definition assigned through the standard traffic offense code book, and it mirrors the same definition on the state level.
And I think the scooters that you see, I'll call them scooters, for those with disabilities, I believe, if properly marked, are allowed on the street. I'll look at Christine
If
to make
there
sure I'm
isn't a
speaking
sidewalk, I
correctly.
think,
And the
isn't
reason
it?
for that is because of the form of transportation that's intended to provide. I think most, if not all, the other things that you mentioned are not allowed on the street, with the exception of cities do have the option to allow golf carts. And back when that came about some years ago, we felt that, I believe our ordinance allows golf carts to cross a street, I believe, but not to actually use a street for purposes of travel. And the reason is because when you look at our community, it wasn't, you could have an isolated residential street where kind of a no harm, no foul situation, but as soon as you jump out on Crawford or some other busy street to get to where you're going, then you're going to be in a dangerous situation potentially. And so that's why the governing body at the time decided not to take the option of allowing the golf carts.
Mr. Trevor, just one other question. In Kansas, does a person have the right to request to substitute the breath test for alcohol with a blood test?
Not at that stage. That is a preliminary breath test, and certainly once the officer determines, or if the officer determines that there is probable cause to make an arrest and the implied consent advisory is read to the individual can request their own type of test, which could include a blood test.
Okay.
But at that stage, they are required to submit to a preliminary breath test.
Okay, thank you.
You're welcome.
Okay, any other questions?
Yeah, just on the standalone sheet that you had with section 133 and section 182.1. 182.1 being seat belts, the increase in the fine for seat belt.
Yes, and Mr. Bingson had previously taken care of that for me in my absence. It went from $10 to $30 effective July 1st of 2017.
Okay, we already took action on that though,
You
didn't
did.
we? Okay.
You did.
I was going to say, is it going up again?
It's still $30.
Right, okay.
It's only
Good.
30?
It's 30.
That's all? Seriously?
It went from $10 to $30. Unless it's a child, and then that fine is $60.
It must be about the lowest in the country. Okay.
Commissioner Davis, I do recall when we spoke of that last time that you were ready to bring it up a little more.
Oh, easily 150, yes.
Okay.
I do have one last question. This is my first time around on these issues. Is it common to do this first and second reading on the same day? Or is there a reason why we're needing to do the first and second reading on the same day?
Well, obviously, from my perspective, I would like the changes to go into effect as quickly as possible. We have prepared for the adoption with the Salina Police Department, and we are using a timeline that would assume adoption and the ordinances going into effect by Thursday. We have prepared for that. If there is a reason that any of the commissioners feel uncomfortable doing the first and second reading today, certainly I understand that.
I think to add to that as well, and Christina, you can correct me if I'm wrong, the standard traffic ordinance usually comes out the League of Kansas Municipalities puts that out because it does aggregate all those traffic ordinance changes or traffic law changes made by the legislature, which is a really nice thing that they do. And those laws that are established by the legislature typically have a July 1st effective date. So you do try to want to get those out as soon as you can, but because we do have some variations to that, it takes a little bit of time to review. So I think that helps. That's one reason we try to push it along a little bit, but it's not a huge deal.
Gotcha. Thank you.
I might add to that, if I may, Mayor,
Sure.
quickly. I think as you go into the next two items, this standard traffic ordinance is fairly routine. As you can see, it prompted some questions, but we are accustomed to doing that. Ms. Trocek has done an enormous amount of work preparing for these next two items, and I think you'll see that as she goes through that, and it's been just extremely beneficial for the city. I think that she's gone to the work that she has. So we, as I understood, the point was that we wanted to keep them all together so that you would be addressing them simultaneously. So I think you'll find that the next two items were what were driving the timing. Is that fair to say?
That is a fair statement. We wanted to use one consistent date for the adoption date to make things as easy as possible for the officers who are using these new ordinances, and our office and the clerk's office who will have to, of course, file those complaints using the new ordinances. We'd like one date to apply to everything so there's no confusion about which ordinance goes into effect on which date.
Would it be fair and accurate to say, though, that these all passed the legislature on July 1st? We're just pretty much playing catch-up, so it's not anything. The compelling public interest may be to get ourselves updated just as soon as possible.
Well, that's true, but we do have the element of the transition to the Uniform Public Offense Code, which is a step. I think that's a significant step from the standpoint of the way the city approaches those types of offenses as well. And that's what I think, not to try to speak for Ms. Trocek, but I think that's what took the significant effort on her part in terms of making that big step that we just had not ever done
And I'm
before.
just speaking to getting to a compelling public interest.
Right.
So should that come up. So.
Okay, thank you. I'll entertain a motion to approve on first reading ordinance 17-10898.
Madam Mayor, I would move that we approve on first reading ordinance number 17-10898, amending Chapter 38, Article 1 of the Salina Code by adopting the 2017 Standard Traffic Ordinance.
Second.
I have a motion and a second to approve on first reading ordinance 17-10898. All of those in favor say aye.
Aye.
Opposed, same sign. Okay.
Madam Mayor, I move that a compelling public interest or purpose exists and adopt this ordinance on second reading today.
Second.
Okay, 7.1B, to declare a compelling public purpose exists. I have a motion and a second. All those in favor, say aye. Aye. Opposed, same sign. Okay.
And Madam Mayor, I move that we approve on second reading ordinance number 17-10898.
Second.
I have a motion and a second to approve on second reading ordinance number 17-10898. Roll call, please.
Commissioner Blanchard,
Aye.
Commissioner Davis,
Aye.
Commissioner Hodges,
Aye.
Commissioner Ryan,
Aye.
Mayor Crawford.
Aye. Okay, that passes. 7.2.
Item 7.2, first reading ordinance number 17-10900, adopting Chapter 25, Article 13 of the Salina Code pertaining to drug offenses. 7.2B, to declare a compelling public purpose exists to allow first and second reading on the same day. And 7.2C, second reading ordinance number 17-10900.
Okay. Christina.
The city is asking the commission to adopt 4 ordinances relevant to, primarily 2 offenses: possession of marijuana or THC and possession of drug paraphernalia. The reason it is not included in the Uniform Public Offense Code is that the Kansas League of Municipalities does not include possession of marijuana and paraphernalia in its book. And so after quite a bit of research and consultation with the police department, the court, the probation officer in municipal court, I made the decision that it would be appropriate to pass a misdemeanor marijuana possession and paraphernalia possession ordinance in the city of Salina. Most of the other municipalities in Kansas that are really of any decent size do have their own ordinances for possession of marijuana and possession of paraphernalia. Currently, it is a Class B misdemeanor for a first conviction of possession of marijuana, a Class A misdemeanor if the individual has a second conviction for possession of marijuana, and for possession of drug paraphernalia, it's considered a Class B misdemeanor. I looked at the number of filings in, well, I'll back up a little bit. The police department had come to me and asked me fairly early into my tenure if I would consider adopting a marijuana and paraphernalia ordinance in the city of Salina. I wasn't ready to tackle that project last year, since I just started in May of 2016, but I told them I would look into it. In doing that, I looked at the number of filings in district court in 2016. They had 145 filings that were marijuana and paraphernalia cases. Most of those cases involved a count of possession of marijuana as well as a count of possession of drug paraphernalia. So I did not double that count when I got those numbers from Todd Heitschmidt over in district court. The other thing I did was I looked at the number of cases that went to trial on those particular offenses. In 2016, there was one that had gone to trial in district court. I also looked at the number of cases where misdemeanor attorneys were appointed. I was trying to look at all aspects to determine if we could handle filing those offenses in municipal court. And the most compelling factor for me, too, was that the city prosecutor's office just recently completed its high-impact project for 2017 to go paperless. Right now, we are completely paperless, and in doing that and reviewing the processes that are conducted by the city prosecutor's office, we were able to cut a significant amount of time from how we prepare cases, how we pull dockets for each docket, whether it be a trial docket or a first appearance docket, and we were able to save a significant amount of time. In doing that, it's my opinion that we could handle an influx of some additional cases, including possession of marijuana and paraphernalia cases. So I, again, spoke with Judge Stoss. I spoke with the appointed attorneys who currently are on contract to provide indigent services, and I spoke with Ms. Everhart, the supervisor in a municipal court, as well as Amanda Swolinski, the supervising probation officer in municipal court, and we all came to the consensus that we felt that we could handle additional filings in Salina Municipal Court. And so I looked at what other cities had done and some of the issues and pitfalls that other cities had fallen into, specifically Wichita, and I tried to develop ordinances that I felt were solid. Of course, I have stayed as consistent with the state law as I possibly could, because we are on solid ground. The more we mirror the state language, the more solid our position is in any ordinance that we adopt in municipal court. So I am asking this commission to adopt, after a first and second reading, ordinance number 17-10900, which would adopt 4 ordinances, and I am proposing we do that under Article 13. The first being a Section 25-201, which contains all the necessary and relevant definitions pertaining to marijuana and paraphernalia. Section 25-202 relating to the unlawful possession of controlled substances, specifically marijuana and THC. The city is not proposing that we adopt any. There are other misdemeanor offenses such as possession of depressants. I am not asking that those be included in this. I'm limiting it only to the marijuana and paraphernalia offenses. Section 25-203 would be the ordinance relevant to unlawful possession of drug paraphernalia, and then Section 25-204 are the factors that are set forth by state statute to consider in determining what is drug paraphernalia.
Two-part question.
Yes.
How is what we're doing now significantly different from the state? Is this on? How is what you're doing now in your office significantly different from the state law? I mean, I'm assuming, well, looking at the newspaper once a week, or people who are wanted, several are for possession of marijuana. Is what you're doing now different from current state law?
Well, right now we don't have any ordinance for possession of marijuana and paraphernalia, so we have never filed cases like that in Salina Municipal Court.
So if a person was
referred to the district court.
So is it a crime in Salina to possess marijuana?
It is.
But you don't charge them with anything?
We would not, however, the charging agency would be the Saline County Attorney's Office, and they would file those charges through Saline County District Court. Since it has occurred in the county of Saline County, they can file the charges over there. So they have filed all of the possession of marijuana and paraphernalia cases occurring in the city, occurring in the county. They have all been filed traditionally in Saline County District Court.
So is this going to balance out, is this to balance out the workload, or
well,
what is the real reason?
Actually, the primary reason was the Salina Police Department asked me to consider it. And I did feel that it was an appropriate adoption to make in Salina Municipal Court to focus on more serious offenses maybe. And I felt that the adoption of the marijuana and paraphernalia ordinances would certainly fall into that category. It's not that I'm trying to alleviate any workload for Saline County District Court. However, in looking at what municipalities have traditionally handled, marijuana and paraphernalia cases are traditionally prosecuted in the municipalities as opposed to the district court if they are misdemeanor offenses. Our handling of those cases will be a little different in that we have already developed a plan for diversions on first offense marijuana and paraphernalia violations. They do not have that in district court. And so it's, could be considered a beneficial program for first-time offenders who are adults to avoid that conviction occurring on their record if they get arrested and the case is referred to Salina Municipal Court. They do not have a diversion program.
So they won't be filed in district court then?
That's correct. They would be referred to my office unless those offenses accompany felony offenses or offenses that could not be prosecuted in Salina Municipal Court. And that most routinely happens when they also have a felony drug offense such as possession of methamphetamine. So because we can't handle felony drug offenses in Salina Municipal Court, the whole case would go over to the district court.
Commissioners, one thing to add to that, Ms. Trocek mentioned the role of the police officers. The processes, the court processes are a little bit different between district court and the municipal court. So when they're called in to testify, they have to deal with how those dockets are managed and so forth. And not taking anything away at all from the district court, but our municipal court is focused in on the efficiency of the dockets for some time and has actually done a really good job. And I think in the end, you will see these low-level charges that do fit the municipal jurisdiction. You will see probably on average less time by the police officers in doing their part on providing testimony and so forth, just because of the difference in approach and docket management that we can have because we're a municipal function, not a district court function. And I think that's a good thing, because if we can get to the be effective with the outcome, if we can save them from another trip of, well, not really a trip, but reduce the time that they have to spend, and maybe save them a trip as well, actually, in testifying, that's an advantage, because that's a pretty difficult job, and I think we can do that. I think we can balance both.
Right. In looking at what this does, I kind of just want to be clear on what it doesn't do. And correct me if I'm wrong, but this does not change our level of enforcement? No. And it doesn't change the offense in any ways that we're somehow trying to make more arrests?
No.
It's
No,
very
I'm not
clear that,
encouraged that.
right. I mean, but I think sometimes people can think, well, geez, if they're going to do a new ordinance because of this, but it's kind of just bringing it out of district into ours. And
Absolutely.
It seems to me a benefit would be that it would help clear up the docket of the district court from some of these low-level crimes. I mean, because we know that they're clogged at that level.
Yeah.
And so community-wide, I think we're probably better, because, and just to speak to police officers saving some time there, well, when the dockets are clogged, they're getting canceled hearings all the time. And I'll brag on municipal court a little bit. We do, I believe, have a very efficient handling of our dockets. And as opposed to an officer going over to district court and maybe sitting all day for his or her case to be heard, and not only the officer, but the evidence custodian who has to bring over the evidence to district court sitting over there all day, they might be in Salina Municipal Court for 2 hours. Mm-hmm. And they only have to transport the evidence literally within the building, which is a benefit as well, because what I routinely would see in district court, due to the crowded dockets, is that officers and evidence custodians would spend a lot of time sitting in court waiting to testify on motion hearings or bench trials or other matters, and it does significantly
impact their ability to do their job back at the police department or out on the streets.
Right. Which is the problem with us because we're short-staffed to begin with.
That's
Always.
correct. Yeah, so
Yeah.
in the most simplest form, it doesn't change the law that's out there. It doesn't change the role of the police department. They can arrest for local and state violations. All it does is change which court jurisdiction that the charge is taken to.
And speaking of crowding, with the use of the diversion policy, would that alleviate any jail crowding? I mean, because we've got such an overcrowded situation as it is. That was my first question, is this going to lead to further overcrowding or maybe the opposite?
I think if anything, it would alleviate it
Right.
because we will offer the diversion program. And another benefit, if you're looking at it from the perspective of any jail impact, is that in Salina Municipal Court, when an individual is cited for most of the offenses that we handle in Salina Municipal Court, they are given an NTA. They are not arrested. Therefore, they are not booked in to the jail. They do not have to post a bond in order to secure their release, which is not the same bonding schedule that Saline County District Court employs. So I would see that as an added benefit.
NTA sounds like something good for one who needs it, but could you tell me what that stands
A
for?
notice to appear in court. So in lieu of them being arrested and having a bond form that gives them their court date, they're given it on a ticket, basically a citation. And when they sign the citation, they're agreeing that they've been advised of their upcoming court date, and they don't have to be processed through the Saline County Jail when they're given a notice to appear in court. And I would not see why most of the drug offenses would not fall into that category of being given a notice to appear, as opposed to an arrest being effectuated.
Okay. Thank you.
You're welcome.
Any other questions? Entertain a motion to approve.
Madam Mayor, I would move that we approve on first reading ordinance number 17-10900, adopting Chapter 25, Article 13 of the Salina Code pertaining to drug offenses.
Second.
Okay, I have a motion and a second to approve on first reading ordinance number 17-10900. Is there any other discussion? No? All those in favor say aye.
Aye.
Opposed, same sign.
Madam Mayor, I move we declare compelling public purpose exists to allow first and second reading on the same day.
Second.
Okay. Motion and a second to declare a compelling public purpose exists to allow first and second reading on the same day. All those in favor say aye.
Aye.
Opposed, same sign. Okay. 7.2.
And Madam Mayor, I would move we approve on second reading ordinance number 17-10900.
Second.
Okay, a motion and a second on second reading to approve second reading ordinance number 17-10900. Roll call, please.
Commissioner Blanchard.
Aye.
Commissioner Davis.
Aye.
Commissioner Hodges.
Aye.
Commissioner Ryan.
Aye.
Mayor Crawford.
Aye. Thank you. Ms. Prochek?
One more.
Oh, yes, one more. Sorry. Thought we were done.
I wish we were.
Item 7.3, first reading ordinance number 17-10899, amending and repealing certain sections of Chapter 25 of the Salina Code by adopting the 2017 Uniform Public Offense Code for Kansas City. 7.3B, declare a compelling public purpose exists to allow first and second reading on the same day. And 7.3C, second reading ordinance number 17-10899.
Okay.
One of the first things that I noticed in reviewing the Salina Code was that the criminal ordinances were fairly outdated. And it was a desire of mine to try to update that code and make it consistent with state statutes that were in place. In deciding how I was going to do that, I came to the conclusion it would be much more efficient and a better use of my time to adopt the Uniform Public Offense Code. The Uniform Public Offense Code is also published by the Kansas League of Municipalities. It is very similar to the Standard Traffic Offense Code, and it operates as the STO book does. It includes all of the misdemeanors in the state of Kansas, with the exception of a few, the drug offenses primarily. It includes it in one nice little booklet. And in reviewing it, the city didn't see any reason to really reinvent the wheel and try to modify and update every single ordinance in Chapter 25 and then a few in Chapter 5. The city felt that it would be more efficient to simply adopt the Uniform Public Offense Code so we don't have to change each ordinance every year that there is a change in state statute. The existing code sections that pertain to criminal offenses are, almost all of them were outdated in some form or fashion, not fatally outdated. They're still good law, but it could be cleaned up quite a bit, and that's what the city is proposing by adopting the Uniform Public Offense Code. And again, if any of you want to take a look at it, I brought it in the event you'd like to do that. I did feel very strongly there would be some sections of the UPOC that we would not want to adopt simply due to the volume that, in my experience, occurs with some cases. And primarily that applied to the giving a worthless check and criminal use of a financial card. Those cases are very time-consuming for staff members. From having worked in the county attorney's office, we filed a lot of worthless check complaints, and we filed a lot of cases dealing with criminal use of a financial card. They're very time-intensive cases. I did not feel that would be a good fit for addition to the ordinances to be prosecuted in Salina Municipal Court. I also consulted with other department heads to determine the need for instance, any of the ordinances relevant to deposits in sewers or damaging sewers. And it was our belief that the language that currently exists in the city code is more comprehensive, and we like that language better than what is in the Uniform Public Offense Code. So I elected to exempt those from the adoption. The same thing with the barbed wire. We like the language of our code better than what was in the Uniform Public Offense Code. That also applies to the placing or maintaining of smoke detectors and the smoking provisions. In addition, the commercialization of wildlife and cruelty to animals, we have language that is a little more inclusive in the Salina City Code, and at this point we are going to maintain that language and not adopt those provisions. There are 3 sections in the Uniform Public Offense Code that would be amended to fit the needs of Salina and be consistent with some of the ordinances that we have previously adopted, including the disorderly conduct section. And we have always maintained an additional section that the state statute does not have for prohibiting conduct to include willfully throwing, depositing, or placing any substance upon any property in which another has an interest without the consent of the other person, in circumstances where the action does not rise to the level of criminal damage to property. I consulted with the police department, and they did want to maintain that additional section of the disorderly conduct ordinance. So that would be amended. The other two sections that would be amended to meet our needs would be section 10.5 for unlawful discharge of a firearm. It essentially expands the individuals, protected individuals, to include the executive director of the Salina Airport Authority or his designee, to address issues such as wildlife reduction, hazard reduction purposes. And then section 10.6 is expanded again to exempt from that behavior an accredited educational institution upon appropriately zoned property owned by that institution. That is not language that exists in the state statute, but after review, it was determined that it should be, that language should continue to be part of that section. So those are the only three that would be amended to include additional language.
Two questions.
Yes.
Does the UPOC have a broader definition of reckless discharge of a firearm in the city than the Salina Code? Such as when folks may not have intended to discharge the gun, but they did, and didn't hit anybody, but they could have.
Well, actually, there is
Not talking about any
no
particular
accompanying
case,
statute
There is
for
not.
unlawful discharge of a firearm. That's why we would be maintaining our current city ordinance for that. In fact, we would be maintaining that the Uniform Public Offense Code does not have an equivalent public nudity or permitting public nudity statute, so we would be maintaining those. They don't have a littering. We would maintain our littering ordinance.
So what you have written here is actually longer than what's in the UPOC, as far as 10.5, unlawful discharge of a firearm. I mean, ours has more, well, actually, we have a lot of instances where a person
The
can
unlawful
discharge.
Yes, we,
Or do we have anything that addresses reckless discharge of firearms in our code?
well,
Yeah,
Actually-
what is defined by reckless?
reckless is.
I mean, serious, I mean, I think that's kind of what you're,
Yeah.
kind of what you're getting at
It's
there.
basically disregarding a risk
Okay.
that a reasonable person would not disregard.
Like
That's
keep,
probably the
like
simplest.
keeping a handgun in your waistband and having it go off?
Well, I don't know how far I want to wade into those waters.
Let's just say that happened hypothetically.
Well, I was just kind of anticipating.
Right.
Well, I mean, I'll go further than anticipation unless I see the eyebrows raised up over here. But is there anything in our current statutes that addresses situations of that type, or is that entirely up to the judgment of the officer at the scene?
Well, I think it's a combination. Obviously, in investigating the case, the officer has to try to make some determination of the level of culpability. Do we have intentional conduct? The state statutes define it in 3 different levels: intentional conduct, knowing conduct, or reckless conduct. And that's something that the officer would have to make a determination about in recommending charges for prosecution. But I don't want to speculate on what facts would meet the definition of reckless conduct, but when you're disregarding a risk that a normal person would not disregard, then that's going to almost always fall into a category of reckless conduct.
So if it did not meet any of these 9 examples in B, there's a good chance that it could be considered reckless.
Let me give you a little bit more insight. I recall some of this prior conversation. Would all accidental discharges be considered a reckless discharge? I think that's really what it comes down to, because if you recall, I think there was some time ago, an accidental discharge in a movie theater. That was what I think prompted our question before. And we had a difficulty drawing the line when we talked about it before between reckless and according to state law and any accidental discharge, in essence, being considered by a typical prudent person as just reckless.
I would say that not all accidents are going to rise to the level of reckless conduct, and the exceptions only apply if there is a lawful defense of one's person, which would not, meet that scenario. If it's discharged at a private or public shooting range. And because it says reckless conduct, it only means that the city doesn't have to prove the conduct was intentional, which is a higher level of culpability. And so what has happened is they have chosen the lowest level of legal culpability that the prosecution would have to establish, and that is reckless conduct. So it goes intentional, knowing, reckless. And so what they've done is they've given the exceptions that we've expanded that would not apply to a reckless discharge of a firearm. If it's shown that it's an intentional discharge, then that necessarily is included in the term of reckless. If you have proven intentional conduct, then you've proven reckless conduct. So they just use the lower level of culpability. However, if you have intentional conduct, it would fall, if not within a more serious offense, it would fall under the unlawful discharge of a firearm. It just is stating that's all the city has to prove, is that there was a reckless discharge. And those exceptions really are very specific to unique circumstances. So I probably did not answer your question to your satisfaction.
Does poor decision-making trump unintentional, accidental, unforeseen consequences? I mean, you can make a stupid decision and still have an unforeseen accidental consequence. So it doesn't necessarily mean the intent was to harm, but it was a situation in which, gosh, what were you thinking?
Right. And that could very well fall within the definition of reckless conduct. If you're disregarding a risk and it's such a gross deviation than what a normal person, I don't know if you want to use the term normal person, but if an ordinary person would use in their circumstances, then you can show reckless conduct. I mean, it really is a gross deviation from the standard of care that we would expect individuals to exercise.
Christina, do you think, and kind of taking that, and obviously you get to choose whether to prosecute on partially the thought of whether you think a judge would agree with you. That's part of it. Do you think if someone is handling a firearm in a place that a prudent person would not typically expect them to be handling a firearm, and then there's an accidental discharge, that could be potentially considered reckless?
Yes.
Okay.
I won't drag you any further.
What's that?
I won't drag you any further.
That's okay. Good
We are
questions.
glad you're on our side, though.
Well, she may not be on our side.
Well, she's on our side.
Oh, okay.
Oh, I'm sorry. What,
Yes.
I don't know if I misunderstood. As far as the worthless checks, was that to infer that you don't prosecute those here?
They're prosecuted. I'm going to let the county attorney's office
okay.
continue prosecuting
Just want to
those
make
as-
sure that the word wasn't out, hey, you can write that check in City of Salina. Okay.
But we are keeping littering, and we still cover littering.
Yes, yes.
And what happens to somebody that's littering? We see this all the time, and
We publicly shame them.
Generally a
you
fine.
can't catch them.
Generally a fine, but sometimes restitution for the cleanup cost, depending on what the property owner, how much money he or she had to spend to clean up the property would be assessed against the offender.
Okay.
Isn't willfully throwing or depositing or placing
Yeah,
any
that's what I
substance on
thought.
any
Sounds
property
like it.
littering?
You know,
Sounds like it, doesn't it?
That's disorderly conduct.
we would typically charge it under the littering for that very specific conduct. The unlawfully depositing or throwing, an example of that is we've had an instance where someone continued to spit on another individual's windshield, and it wasn't just spit, but it was
Nasty.
Okay.
yes. And it didn't damage the car, but certainly it was conduct that the owner of the car didn't appreciate, and it was conduct that continued to be repeated. That would be an example of the type of conduct that could be prosecuted under that additional subsection of the disorderly conduct. If it is throwing trash or debris, then we are going to either charge littering. If they're doing it on the roadways, there is an STO provision for placing certain items on the roadways. So we tried to look at the facts of each case and determine the appropriate charging, whether it be littering or under the disorderly conduct statute or ordinance. Generally, we do it under littering.
So TPing a house would be more littering or disorderly conduct?
Why do you want to know? That would, it could, sometimes we have officers who cite under both. I try not to duplicate the charges because it's not my intent to aggregate fines or anything, but that would, there would be some people who would see that more as a littering, or some people who would see it as a disorderly conduct for depositing a substance that doesn't damage the yard, but certainly it has to be cleaned up.
Right.
Okay. I'll bring it back to
Mayor, I'm
Go
sorry,
ahead.
Mayor, if I may, and with Ms. Trocek's permission, I had opportunity to review this, but I see there is one thing that I overlooked on some carryover language there in 10.59. First of all, I suppose everyone might like to be assured that it's not the executive director that's generally involved in the wildlife hazard reduction. It is a designee.
Well, if he's the best shot, we want to.
Right, I'd already made a note to self to stay on
point-
Tim's good side.
The point I was making was we do have a gender-specific pronoun there that we can fix, I think, easily by referring to the executive director's designee instead of his. And I missed that that would now be the Salina Regional Airport rather than municipal. So with, if Ms. Trocek concurs, I would suggest that we amend that as you consider the ordinance.
And I do concur with that.
Sorry, I missed that on the earlier pass.
Hey, Mr. Bankson, while you're on that, would you look at number 4? And is that all inclusive? I mean, that would obviously be in the discharge of their duties. We're not giving a free pass to those 3 groups of people, are we? Just as a housekeeping.
The
I don't know how important all of the words are.
yeah, that's a good. I don't know the answer to that question as to
Okay.
whether that.
But it's
You
been
mean
there a
as to
while.
whether 9 is even necessary by virtue of that language? Is
Right.
that the point? Yeah. Whether those that are involved in that effort at the airport, as is necessary as you might expect under FAA regulations, meet all of those criteria, I do not know as I am reading that quickly, but.
Okay, any other questions? Bring it back to the commission for action.
Madam Mayor, I would move that we approve on first reading ordinance number, let's see, which one are we on? 17-10899.
Right.
Amending and repealing certain sections of Chapter 25 of the Salina Code by adopting the 2017 Uniform Public Offense Code for Kansas cities with the following change on item 10.5, item number 9, changing to, changing the gender-specific pronoun and correcting the name to Salina Regional Airport.
Second.
Okay. Have a motion and a second to approve on first reading ordinance number 17-10899 with 2 amendments. Is that correct? All those in favor say aye. Aye. Opposed, same sign. Okay. Item 7.3.
Madam Mayor, move to declare a compelling public purpose exists to allow first and second reading of ordinance number 17-10899 on the same day.
Second?
Okay, I have a motion and a second to declare a compelling public purpose exists to allow first and second reading on the same day. All those in favor say aye. Aye. Opposed, same sign.
Madam Mayor, move adoption on second reading ordinance number 17-10899 with the amendments previously stated.
Second.
Okay, I have a motion and a second to approve on second reading ordinance number 17-10899 with the amendments. Roll call, please.
Commissioner Blanchard.
Aye.
Commissioner Davis.
Aye.
Commissioner Hodges.
Aye.
Commissioner Ryan.
Aye.
Mayor Crawford.
Aye. Thank you very much.
Thank you.
Passed. We passed all 3. Seven point 4.
Item 7.4, resolution number 17-7485, authorizing the mayor to enter into a supplemental agreement relating to the development agreement for the Salina Downtown Star Bond Project District.
Jason?
Mayor and Commissioners, since I have the next 3 items, we'll be chatting for a while. So, to start with this one, as you know, the vision and beginning organizing of the downtown renovation began in about 2013 with the city in Salina 2020. That's when efforts began to be coordinated. I'm going to kind of go over a little brief overview for those who might not be familiar with it, but not getting too much detail on the history. But the revitalization project now envisions the redevelopment of approximately 157 acres within the downtown area, and potentially up to $155 million in total public and private investment. There are multiple core components, including a 67,000 square foot multi-sport athletic facility that's open and known as the Salina Fieldhouse. An automotive museum of classic, high-end classic cars, renovation and expansion of the historic Stiefel Theater, construction of new streetscape and infrastructure on Santa Fe, which you learned a lot more about today, earlier, construction of a new 114 room plus or minus Homewood Suites hotel in a small conference space to go along with that. Construction of a approximately 47,000 square foot alley entertainment center that includes bowling and other entertainment aspects. Renovation of downtown space for an old Chicago restaurant. Construction of a new location for the University of Kansas Medical School nursing program. And development of new and refurbished retail and residential space throughout the downtown core. Prior development actions taken to date by the City Commission have included the creation of the Star Bond District, the Tax Increment Finance District, and 3 separate community improvement districts. Also, the governing bodies approved a project plan which was accepted by the Kansas Department of Commerce and is required for the Star Bond process. The development agreement, I'll talk a little bit about the development agreement, and then I'll ease right into the supplemental agreement, which is today's action. The development agreement was approved on January 23rd of this year between the City of Salina and Salina 2020. The primary purpose of the development agreement is really to outline the roles and responsibilities of both the city and the master developer, which is Salina 2020. More specifically, it addresses development of the downtown project, the project financing options, the issuance of the Star Bonds, the certification of project expenditures, the use of various statutorily enabled incentive districts recently established by the governing body, and has numerous typical general provisions you would expect to see. It's the development agreement is complemented by a required supplemental agreement that's referenced within it. That also provides, the supplemental agreement also provides for the transferee template agreement and the transferee concept, which the transferee is really what we would call, the easiest way to think of what that is their third-party developer agreements for independent projects that may come along, and we hope do come along. So as we transition to the supplemental agreement, it's referenced in the development agreement in multiple sections. Those sections require the supplemental agreement. And I do state in here prior to execution of the hotel transfer agreement, so the timing is pretty important there. And in the development agreement, the hotel transfer agreement is also linked to some other core project agreements. So there is a timing layout with regards to how these complement each other. Real quickly, in this case, because of how this is set up with multiple properties and potential development, not just core potentially known projects, the supplemental agreement in essence helps fulfill and finishes out the development agreement. So it kind of helps you to understand that. Typically, if you have a single developer, a single parcel of property, everything's laid out in the development agreement. But because we're dealing with downtown properties and some prospective type development as well, the supplemental agreement comes into place. The intended purpose of the supplemental agreement is really to establish shared goals and objectives to attract a diverse mixture of retail, development, restaurant, multifamily housing, office entertainment, hotel, and other development uses within the downtown districts. It's to address the creation, administration, and distribution of the public finance incentive funds. And it's to provide for the selection of transferees or third-party developers, but private business entities approved for incentive funds. The application process and general contractual requirements. So those are the big things generally that it's intended to do. As we look at the key provisions of it, you have basic term definitions in Article 1. Establishment of a new business TIF fund or tax increment financing fund. That's to deal with tax increment financing incentives and holding of those funds. New retail improvement CID fund and existing retail improvements CID fund. The community improvement district funds, which are the extra sales tax that are approved to be in downtown, will go in two separate funds. One again is for new retail improvements. The other is to deal with existing businesses. A transferee project selection process is in Article 3 based on certain project goals and objectives, which are included as an Exhibit E. Please note that the third-party developers for the hotel project, alley project, Old Chicago, car museum, and Stiefel improvements are not required to submit an application under the supplemental agreement. And the reason is because those processes are already dealt with in the main development agreement. The supplemental agreement in Article 3 also deals with recusal and substantial interest provisions. The Article 4 deals with the administration of public finance proceeds, and those provide that for all projects there is joint approval by the city and the master developer that's required. So a project cannot be approved unless both parties approve it. A negotiated maximum incentive cap will be applied with a designated annual allotment amount and payment schedule. So in essence, if a project application is filled out and both the city and the master developer agree with that application and decide they should wish to fund it, there will be a certain incentive amount. We'll have to jointly agree on what that amount would be. And that would be the cap. In essence, the total is what the cap really means. And then with that also, what time frame that would be spread over and what the annual allotment would be. The project funding priority is based on the date of completion for approved projects within each funding fund source. So as we think about, and we do have to think about ahead of time, the total amount of dollars in the funds and what's available, so we'll always be tracking that as part of the process. But in essence, if there are multiple projects that are happening at the same time, and we hope there are, actually it's a great problem to have, is to deal with multiple projects. The project that is completed first will become first in the priority order. For annual funding allotments to occur, funds must be available from the respective public financing funds. And again, there's different pots. There must be funds available in order for an incentive to be provided. What that means is that you don't have to go into your general fund or any other fund if the funds aren't there. And I'll talk about that here a little bit later. Then they're on hold until the funds come into that. Again, and if there is an annual allotment funding shortfall, the payment is addressed in the order of funding priority for each annual funding cycle, presuming funds are available. So you'll look at the priority each year, and then we'll go through that. And if one of the projects is, I'm going to make up, say, fourth or fifth as a priority and funds are not available, then that project will not be provided its allotment in that particular year. We start over in year 2. Let's presume more funds are available. If all can be paid for year 2 and there's additional funds, then that can be made up. But yet we have to have adequate cash flow through the fund in order to do that. And again, part of the purpose of that is to make sure that we're not allocating more than it's available, and there's no concern from the public that these incentives are coming out of the city's actual tax dollars other than what's generated by the project and what's established here. Any funding surplus is to be held in reserve for the future, additional transfer projects, or for potential funding shortfalls in the future. There's always a possibility you might not have shortfalls early, but you might have them later. So if the surplus can be used for either new projects or for that. The supplemental agreement also provides for project goals and objectives for general and retail restaurant development projects requesting public financing. Again, Exhibit E. The objectives include, but are not limited to, attracting businesses, restaurants to downtown that create capital investment to increase the tax base and enhance aesthetic quality of the downtown, have strong market brand and local appeal, offer high-quality products, and increase property values, increase jobs, and make downtown a more desirable place to live. A public financing request application is shown as Exhibit B. That application requires information about each proposed project, including developer information, a detailed project description, physical characteristics of the project, a demonstration of property control and conformance to land use codes, detailed project funding, which are sources, detailed project costs, which are uses, tenant information if there's to be a separate tenant, and demonstrated project feasibility. And then also is in Exhibit C is the actual transferee or third-party development agreement template. And so that's the basis for the future agreements. There could be some modifications to that, but we actually expect the projects to be very close to the template. You got my apologies. We're going to continue, but I see I had an extra copy-paste on here, repeating a couple things. The supplemental agreement also includes project performance milestones, which are really important. And those include project commencement requirements, when the project starts, including the date, the required permitting, a guaranteed maximum price contract with the general contractor, documentation of financing, so the financing is there, a critical path schedule, which is obviously important, and an executed lease if it's applicable, quality workmanship expectations, and an established project completion date. And so those are the pieces that you'd expect to see with regards to the project. Also, provision to reduce the public financing obligation for failure to comply with either the commencement date, the start of it, or the completion milestone, including a failure to commence or complete a transferee project on time, results in a 25% public financing obligation reduction within 120 days, 50% reduction after 120 days. I'm sorry, that says 100. Yeah, if it's, let me reread that again here, make sure I don't have a typo here. I may have to look it up to double check it here. 25% public financing obligation within 120 days, 50% reduction after 120 days, and termination after 180 days. Certainly you don't have to exercise those, but the city has the right to do that, and there's communication expectations with the master developer. Includes relief for project timeline disruption caused by delay in streetscape construction is included. A provision addressing the responsibility of transferees to pay property taxes, which is pretty important since that becomes part of the increment and is an expectation. And also the remittance and reporting of sales tax. A provision to address damage, destruction, or condemnation that may occur during the agreement term of the project, because things can happen over the term. And so it addresses that. And a provision addressing rights of access, inspection, and record keeping. As included in the supplemental agreement, requests for public finance assistance for transferee projects will be considered effective January 9th, 2018, on the presumption that this is approved, and that's approximately 90 days from the adoption if this agreement is adopted today. Funds will be distributed from the appropriate project fund for approved transferee projects beginning on November 1st of 2019. That's when the actual funds would be beginning to be distributed. And that, again, is contingent upon funds being, dollars being in those funds. I want to go back and reemphasize, though, that the acceptance of transferee projects for review it would commence effective January 9th of next year. So it's really right around the corner. That's, again, 90 days from now. The reason I say that is because a lot of people are involved in the conversation and putting this together, but then there are a lot of people that aren't involved in that as well. So it's important that they know that. So if they have a project proposal that they've been contemplating and they have the property or can get control of the property and can meet the requirements, that they start working on that immediately, because it's possible that we have no projects ready. I don't think that's going to happen, but it's possible we could have 3 or 5 or 10 projects that we might review. And quite honestly, the more quality projects, the merrier, that the city and the master developer have to contemplate. So I do want to emphasize that for those out there that are possibly looking at a project, whether it's, it could be an existing business that's a change in model or a renovation or whatever that can meet our requirements, or it could be a new business concept that we haven't even seen in Salina. So that's why we wanted to emphasize that. The supplemental agreement has been thoroughly reviewed by the city's general legal counsel, bond counsel, and financial advisor. The primary role of the review with regards to the language and so forth falls with the bond counsel. The public finance team finds the terms to be acceptable. Salina 2020 has also reviewed the final agreement terms and is in agreement with them. So with that, the staff, when we look at the strategic plan, which we always look at when we look at these items, we think it meets goals 1 and 5. Goal 1 is the city will create a community of mixed-use quality development and redevelopment, and I can't think of anything that meets that one any more directly. And goal 5, the city will maintain commitment to making downtown Salina a thriving and vibrant center of the community. We certainly think it meets that as well, if we can be successful. From a fiscal perspective, with your fiscal note, since a transfer development project public financing is dependent upon tax increment finance and community improvement district cash flow balances, this action is not expected to add any cost to the city's annual budget and is considered to be fiscally neutral. And that's what the supplemental agreement actually addresses. Now, when you look more broadly at the STAR bonds and all that, there are different aspects, but as we just talk about the TIF and CID portions, there would not be expected to be any possibility of use of other tax dollars. So we have 3 alternatives for you, the typical 3. First one is approve the resolution authorizing the mayor to enter into the supplemental agreement with Salina 2020. The second is to provide direction regarding desired amendments to the proposed supplemental agreement. And the third is do not approve the resolution authorizing the mayor to enter into the agreement. Once the agreement is approved on the assumption that it will be, whether it be tonight or at some other point, the city can receive, review, and enter into the core project transfer agreements. Remember, we talked earlier that you have to have this to get to the hotel, and the hotel links to the others. So we're talking about the hotel, the Alley Entertainment Center, and the Old Chicago. And approval of these core transfer agreements are a prerequisite to soliciting bids for the Santa Fe Streetscape project, where we discussed the design concept earlier today. So if you look in the development agreement, the development agreement calls for all those transferees that I just mentioned to be in place before the city would be obligated to move forward with actually soliciting bids for the construction of the streetscape. So our time frame for that, just to make sure everyone is aware, is to have all that taken care of by the end of this month. Because we'd like to, as you know, we'd like to solicit bids early in November. And there's a few reasons for that. One is we think the bidding climate is good. We think we'll have many bidders that are interested in the project. It gives the bidders adequate time to plan and bid for this project, potentially ahead of some other large projects of similar scale, and that helps us as well. And the construction timelines are very, very tight with regards to the phasing and the completion of each phase. So we need to get moving as quickly as possible if we would hold tight to the 18 and 19 construction time frames that we have out there. So those are the reasons for that. I'd be happy to answer questions. Mike Scragg, your deputy city manager, has been integral in putting together a lot of this throughout the time. So if there's a question I can't answer, we'll look to Mike. And also with Salina 2020, we have Larry Brittigam locally. You all know Larry, and Bob Johnson, the legal counsel for Salina 2020. Others were not able to be here but would have liked to been. So I think among all of us, hopefully we can answer any questions you have. We'll try our best.
Questions?
Yeah, before I ask, I do have a few questions, but I do want to make a disclosure that I did welcome Mr. Brigham, Mr. Johnson. I did get a phone call this afternoon from Trace Walker, who was out of town, mentioned that you guys would be here. Don't really need to, just for the benefit of everybody being on the same page, didn't really go over anything that we haven't already gone over in these public meetings. But I do have a few questions and lingering concerns that I held back in January, but we'll kind of leave those on the table now, because I think one of the things I just want to get through is to make sure that we have everything we could possibly have right now to make sure, and I'm looking toward that transferee agreement part because we're up against the street. We're in an 11th hour right now on our streetscape. And so my questions on the schedule are this. As part of our approval back in January, there was a January 5th letter from then Department of Commerce Secretary Suave, and dated January 5th. I had asked Holly to make me a copy, and she graciously made all of you a copy of that thing. But on that January 5th letter that was included in our approval process, there were 9 conditions by which the Commerce Secretary gave approval of this. And Mr. Johnson, you probably may be the best person to answer the concern. My concern is that if we have a temporary or a conditioned, and I looked at number 6 on this, on the last page, last paragraph, that the city entered a binding development agreement subject to my approval, being the secretary, to fund and build the private component projects. Do we have enough time built into our process? I'm assuming that by development agreements, since we kind of passed that on to, we didn't really address development agreements in specific in the development agreement. Would those binding development agreements be the transferee agreements? And my question is, do we have enough time to hit our end of October deadline to get all that happening?
Yeah, I do believe that this number 6, when it says the city entered into binding development agreement subject to my approval to fund and build the private project components, that is referring to the transferee agreements.
Okay.
And so far, I'll be honest, we have a pretty tight time frame, but they recognize in the development agreement, which has already been approved, what those are. And I think when we look at the template for the transferee agreements, those would be in line with with what they would look for. And so I would expect that the review should be pretty quick, actually. We would certainly press them on the timeline to try to make sure that we get that approval pretty quickly, but I don't think they would see anything that they wouldn't expect to see, and I think it would be very much in line with what they would expect. And it was designed that way, both from Salina 2020's legal review and also from our bond counsel's legal review. So I think we're in agreement that we believe that what's in there is what they would expect to see, which should help us move the approval pretty fast.
Right.
But I don't want to speak for Salina 2020, so I would defer to Bob or Larry if they have a thought on that as well.
Right, yeah, and just in that first question in particular, do we have a timeline for things like that?
Yeah, I would really just concur with Jason on this. I think we absolutely would be in line with what Commerce is expecting to see with regard to the transferee agreement. They've seen a template of it, so they wouldn't be surprised by the content of it. And as Jason said, it won't be heavily changed or revised by those first projects coming in the door. So I wouldn't expect it would be a long turnaround on behalf of the Department of Commerce. Really, when Department of Commerce's timeline is they need those in place before bond issuance. Obviously, that's further down the road than us as a team along with the city wanting to get those done and move forward with streetscape design. So that's our own internal timeline. Commerce's timeline is to get that done before bond issuance, but they're also sensitive and cognizant that we've got our own upfront timelines that are just a development reality that they'll need to be responsive to make sure that we get done what we need to get done so we can design the streetscape and also design the hotel and the alley in Old Chicago as well.
Right. Okay. That was just a concern because I know we're tight on time.
Yeah, no, that's a very good question.
And then just so when you say that we're not substantially different, now we did vary quite a bit on our size of our field house. We started out at a certain size and done. Are we pretty much are we expecting to get in a transferee agreement the same footprints and rooms and sizes and everything of those projects that were approved back in January of this year?
I think a rough approximation. I can't say exactly it'll be down to the T that amount of rooms, but it won't be 50 rooms versus 150.
Yeah, and
I'm
not so much worried about the physical components. I'm worried about increment generators.
Right.
And I just want to know that it doesn't change anything to where,
The conceptual projects that were in place at the time we approved the development agreement are the same projects that have now been working towards design incrementally to get to this point as well. And they
Okay.
will be better defined in the transferee agreement. And I don't expect that they will be drastically different from an increment generation standpoint than what we projected initially.
okay. And just so I appreciate the attorneys and what they do, because it's a very difficult project. And the structure that we've chosen, I think, really makes it even that more difficult. But the concern that I would only have beyond that is when we start to look at when we start looking at sort of this supplemental agreement, how it lays out third-party developers, and it probably fits best into the box of looking at Exhibit E. And because like I said, you guys appreciate the attorneys doing the stuff, and this really isn't a legal question. This is kind of more of a market mix, retail, recruiter type question. And that is that if we're going for all these goals and objectives, and we're going to require certain levels of experience and demonstrations of success on past projects, what are we doing to make sure that we're matching up? How do we make sure that somebody that comes in and says, hey, I got a transferee project, and it's because it's what they do, how are we ensuring that it goes towards generating the increment that we have determined to be there for in the feasibility study, to be there for increment generators? What in this agreement points to allowing for a retail mix that is most marketable, and what if just for lack of a better thing, what happens if we get 20 pizza restaurants?
Sure. Yeah, you mind if I jump in really quickly? I think there's maybe two parts to that answer. The first one, I'm glad you hit on this, because this is something we thought through and wanted to make sure was out there publicly for folks that do want to make application, and that's that we're really looking at everybody who comes in with an application. Track record of success is attractive, but at the same time, we don't want to shut out somebody with a good idea that might not have done a project before, or may have only done one or two projects previously. So we do have one of these goals in here about, that those first-time or early-stage developers won't be disadvantaged because of a lack of a significant track record. I think that's important. But to answer the second part of your question, the application for somebody to come in and put their project in front of the city and in front of the master developer and say, I'm ready to go, and here's what my project is, includes a demonstration of essentially projections of what they believe that their property tax increment is going to be, or their sales tax increment is going to be, so that we can jointly view that in light of the greater project, so that we can think about in the future sales tax generation to pay back STAR bonds. We can think about how much money is going to be there for TIF and CID dollars for future projects as well. And while it doesn't have to be exactly married up that what a project's going to create is exactly what they're going to get, that'll be a rough approximation for us to have a starting point that makes sense to give a project a certain designated amount of money, in that they would be generating that increment in the first place. Again, not a requirement. It may make sense in a certain case to give them more. It makes sense to give them less based upon all of the projects we have and putting those puzzle pieces together. You're right, it is complicated, but we've got a good team to address it, and we've got this framework to address it that'll make sense to put the puzzle pieces together. But it's through those projections that we'll know how it'll work, in that we'll have enough funds, essentially, to fund the projects that we are allocating to.
Right.
Yeah, I totally agree with that. And as you know, it's to answer that question, it's not a perfect science, and so we'll have to apply judgment. And I think as we review the information they provide, we may have further questions that'll help us clarify that issue, because ultimately, we know that we only have so many incentive dollars, or we'll probably have so many incentive dollars, and we won't know early what that number will be. So you want to be careful and try to get the most impactful project you can early on, and really throughout the process. Quite honestly, if we come to a point that we're having trouble making that determination, we can always go and agree to ask for someone else to help look at it and analyze it and give us their thoughts as well. So we're very open to any tool that we need to make the right decision, because it's not going to be that easy in all cases.
Yeah, I would add, if I understand your concern correctly, that it's dilution of the existing tax base rather than increasing it. There's a couple of itemized objectives, general project objectives in Exhibit E. One is attracting capital investment that increases the future tax base, and the other is introducing new economic activity and sales tax generation within the downtown area. So I think it communicates the expectation that it's going to be a tide that raises all boats, not something that kind of diffuses the existing tax base, and at least gives us the basis to apply some discretion in that regard.
I mean, there are a lot of things in here that I think are going to come up that we may or may not have contemplated. I mean, I think we all expect that. One of the things that, and I had a conversation with you, Mr. Gage, about this, and it's been several weeks ago, is what do we anticipate being, I did notice that we got something in there that we will have, if something is denied, that there will be an opportunity to be some sort of explanation as to why that was denied. I think that's for transparency, I think that's a really important piece. But what happens if, you know, with the anti-poaching, somebody can't close down in one part of town and open up in the Star Bond district for Star Bond proceeds. But I'm just kind of curious what we do if in this transferee agreement part, what weight would something have if a big place in, let's just say, the mall says we want to relocate, and the mall isn't doing great, and says we want to relocate, we're either going to leave town or we're going to relocate downtown. Well, they're not eligible for Star Bond proceeds, but they might be for TIF and CID. How do we deal with the project like that? Because I see it in the best interest of the city, being one half of the deciding vote, to say, boy, we don't want that, we don't want those jobs to leave town, we don't want that sales tax revenue to leave town, and even though they don't get the Star Bond proceeds, which helps to pay off those bonds, we will receive benefit, especially if there's somebody that draws a lot of customers into the downtown. Any way we're able to do that, because it's not in the best interest of the Star, you know, the Star Bonds to say, boy, or you know, they wouldn't get Star Bonds, but it would go towards paying those off.
Fully recognize exactly the concept that you're talking about. It's a common discussion in light of incentive projects, and I think it speaks to, well, it's not a legal requirement in the TIF and CID statutes. It speaks to Mike's point about the discretion. You know, if the city's vote is that's not a good deal for the city has that right to discretionarily decide that it's not the right project for the city. That may be one reason that you'd make that decision. There are a whole host of reasons that we're all guided by these goals and objectives here, and some of them speak to that, as Mike said, you know, increasing the tax base, complementary projects, making sure we don't have 20 pizza restaurants. That's a consideration when the city is taking into account this may be a great project, but it may not be a great project for this location. And so there is the ultimate discretion on behalf of the city to make that decision.
Okay. Yeah, I just want to make sure there's not something in there that allows somebody to say, if it's not a Star Bond generator, we don't want it.
No, it's left open, and there's a reason for that as well. You know, when you look at this, ideally, we want a project from the financial side, ideally to help fill up the Star Bond pot and make it successful, and then the TIF and the CID pots so that we can continue to perpetuate success. Those are ideal. If something isn't able to put money into the Star Bond pot, that's sort of an initial strike. We'd have to look at that. And so, but it doesn't, we didn't want to kick those out because, quite honestly, it may be so impactful to other businesses that do contribute to the Star Bond pot and the other pots that it might be worth considering. And without knowing what it might be, you certainly wouldn't want to automatically exit out. You'd want to apply that same judgment that Bob talked about.
Okay, and I'll exhaust my questions with this last one, and that is do you anticipate or do you see any benefit in having? But let me ask: has Salina 2020 hired any sort of retail consultant to recruit?
We have a consultant we've been working with that's worked on other Star Bond projects that can help formulate strategy.
Okay.
So
do
certainly
you see
in
any
thinking
benefit
of,
in there just from a transparency standpoint? Because I think Exhibit E is nice to have, it's very vague. It'd be nice to be able to look at a list and go like, hey, this is our strategy. You know what I mean? And check off things when it comes off and amend it when it needs to be amended.
I mean, I should be clear that it's not there are firms out there that specialize in putting in implementation of major retail programs. That wouldn't be this person. This is somebody who's been involved in other Star Bond projects that just knows the process and knows the right way to build generators in. It wouldn't be a Torg or somebody like that that's truly a retail consultant that goes out and finds tenants. We don't have somebody like that.
Well,
lined up.
we have such a changing retail landscape out there that it's one of those things that long term, we're talking about a 20-year payback on this project, and nobody's crystal ball is, is going to be that accurate to begin with. But I'm just kind of wondering what we might, if this, and I guess my question is, does this supplemental agreement allow for addendums to be placed into it that will strengthen it over time, or is this just you pass it and this goes on? Is there a provision to add addendums at the agreement of the two parties?
Well, a couple of things. Any agreement is able to be amended when the two parties that enter into it agree on an amendment. So from that perspective, you could amend it at any time in the future if both parties wanted to do that. So nothing would shut the door on that. Kind of coming back to that, though, that Exhibit E with the project objectives and the restaurant and retail objectives, it was put together fairly broad for a reason. And the reason is when you don't, it's really difficult over a 20-year time frame to anticipate exactly what that characteristic of the prospect is going to be. How's this one going to be different from that one and the other? And so if it was created like a funnel, which you screen and then you screen again and again and again and again, and then it finally falls out the bottom, the problem is you risk possibly accidentally screening out a really good project because you just didn't really think about, you didn't put those criteria together right. You may kick something out that later you said, oh, I cannot believe that our criteria did that. We just didn't think about that possibility. So that's one reason it was intended to be fairly vague as far as the project objectives, is just not to bind us and create a mistake later. But again, it goes back to making strategic decisions when the projects come forward and analyzing those projects in the best way we can. But going back to the original question is absolutely, if the city and the master developer should say, hey, this makes sense for us to amend the project, or the supplemental agreement, when both parties agree, you can agree to amend it and add whatever you'd like or modify what you would like.
I'd concur. I don't have anything to add.
Any other questions? Thank you.
Thank you.
Bring it back to the commission for action.
Madam Mayor, I move that we approve Resolution 177485, authorizing the mayor to enter into a supplemental agreement relating to the development agreement for the Salina Downtown Star Bond Project District.
Second.
Motion and a second to approve Resolution 177485. All those in favor say aye. Aye. Opposed, same sign. Okay. Passed. Okay, we're on to item 7.5.
Item 7.5, report on prior actions related to amending the city's personnel manual, Article 4, equal opportunity, and Article 5, sexual and other workplace harassment policy, to add reference to sexual orientation and gender identity.
Okay, Mr. Gage.
Yes, Mayor and Commissioners, we went back. I didn't want to rely on my recollection last week, so we went back and checked the history. Again, at your last meeting, you asked about the possibility of adding reference to sexual orientation and gender identity to the personnel manual. In this instance, the policy inclusion would apply to the organization and not be affected by the prior public vote. Some people get those confused. The public vote was the city's attempt to regulate through our Chapter 13 other businesses and entities in our community. But so this, what you're talking about does not do that. It only affects what you want to do with this organization, just to be clear on that. You'd asked if we'd taken further or prior action, and we had it in some form. You'll find that in your staff report and resolution dated December 17, 2012, it was brought up as part of a personnel manual update, and it was brought in exactly that way. The report indicates that the personnel manual was previously updated to include references to sexual orientation and gender identity in Article 4, equal opportunity, and Article 5, sexual and other workplace harassment. So that we brought in the harassment as well. And that was by action of the governing body way back on July 23rd of 2012. That action followed a prior city commission action amending Chapter 13, which was the more public equal employment opportunity action. And so in essence what you had is you had a city action that you had the action to apply the protections across the community, and then you had an action by the governing body to make sure that our personnel manual reflected that. And then you had the repeal of the broader community action, and then this was brought in with the personnel manual update and was at that point then rejected by the governing body at that particular time. So it was actually removed from the personnel manual at that time. A couple things to think about as you look at this too, and I'm not quite sure back in 2012 why it wasn't addressed in that way, because we've talked about the personnel manual, and that addresses the employees obviously. Didn't talk about public accommodation, which you wouldn't have needed to talk about necessarily with the broader community ordinance, because you were applying that to ourselves as well. But when that was gone, if for those who support this issue, you would definitely want to look at public accommodation as well as the employee portion to be consistent. As I mentioned last week, there's some contemplations you have when you look at this, and obviously, you know, you'll have the public remind you of the vote, the broader vote, which was on the broader regulation. And then also, as you think about transgender, the issue of the restrooms comes into play. And I would interpret, at least based on what we've studied, know that if the protection is there, then that means that the person could go to the restroom based on the gender that they identify with. And as you know, that became quite a talking piece from before when it was discussed, and that's one of the issues that people tend to migrate towards. Another issue of contemplation is if you have it's professional dress in essence, and because if you're a transgender person, I'd say in particular, you may dress again based on the identity that you affiliate with, and in that case, that doesn't actually always add up to those who don't identify in that way, and so that can sometimes create complaints, concerns, and so forth. But if you approve this, then I don't know that, and it may be a legal question, it may not be, but from a practical perspective, I don't know that you would be able to say, especially with a municipal government, even versus a private-based entity, hey, we don't like the way you dress, if you have this protection in place in that. So if a male dressed as a female, might draw a lot of attention, but I think that if this is applied, that the update would protect that person's ability to dress in the way that they identify based on the gender that they identify with. So those are a couple things that generally pop up as far as discussion items. If you decided to move forward and want to amend the personnel manual, and you did want to address not public accommodation, but I guess it would be public accommodation, we would be looking at another action. We'd determine what that is. It likely would be a Salina Code action. It could be a resolution, but I think something like that would likely be in the Salina Code. The logistics of it's not really here nor there. It's not really that relevant. It's just to let you know that the personnel manual only addresses one piece, and we'd have another action if that's where you went. We'd bring them both back at the same time. So with that, we do want to cover real quick, there's been a change in enforcement. You know, at the time that this all came about, the state nor the federal government were enforcement agencies or entities for this category of human rights protection. Since that time, and not too long ago, the prior President Obama and that administration redefined the definition of sex for the EEOC for purposes of protection. Just recently, The Trump administration, through the Attorney General, has indicated that they want to define that back the way it was. So it appears that there would be no federal entity or no state entity to go to if someone felt like the city didn't apply the policy in the way that they should, and there could be impacts to that. So normally, if you have a human rights violation, you have the state, and as a matter of fact, if we had someone that felt they were discriminated against based on the current categories of protection, we would actually encourage them not to go to our own human relations because it's a conflict, to go to the state in that case, and they certainly can always, if there's jurisdiction, go to the federal government. But in this case, you would not have those avenues. So you may have other enforcement questions about what someone can and can't do, and I could play attorney. Well, I've got the microphone and Greg's listening, but I think you'd be better off to ask Greg those questions.
Do you have in the first instance that you said that there was an executive order prior to the last one rescinding the definition? Do you have a date when that took place? Was that prior to this 2012 or was that after?
I believe that was well after.
Okay, so that exists. I mean, all that
you did not
existed
have
when we looked at this thing before.
Correct. You did not have the federal or state protection administrative remedy to go to at that time. That's correct.
Okay.
It came in between, and then just appears to have left last week.
Okay.
I'm wondering if, I've given a lot of thought to this because, of course, I spent 25 years working on protected classes. And, I think equal opportunity is really important to our city and is to me. And decisions we made in 2012, I remember those very astutely. Anyway, I just wonder if it wouldn't be better, or if the commission might think it'd be better to delay this action until we have so much right now on the plate of the commission. I don't think we can give I think we should address accommodations if we're going to do this. If we're going to pass this, we need to address, I think, the issue of accommodations. And I went through and was thinking about what we have, and I'm thinking about the short term that Commissioner Blanchard and I have left. But we have, and I was hoping to get some kind of draft agreement with the county on Kenwood Park. That was just part of my little platform when I ran way back there. Staff, I think, is still working on a draft agreement on special assessments. We may possibly have a strategic planning session before the end of the year, and I think we still have, staff has to wade through the information on the agreement with the connection of water outside the limits. So Mrs., and I've forgotten her name, doesn't have to wait any longer.
Ms. Bigham.
Anyway, so, and we have an evaluation to do. So just going through what we have left on the plate of the staff, I'm thinking it might be smart, or at least make sense to me to, when we do this, to do it right and not to just hit and miss it. That's just my opinion on it. What anybody else thinks?
Well, I can appreciate that, and I do appreciate that staff has a lot going on, but I tell you what, just to kind of bring it into perspective with kind of what some of our kids are going through over at one of our high schools, I think it centers around having a safe and inclusive environment. I want that for our work environment. I think this probably could have happened 5 years ago in 2012. I don't know why it didn't. But
Well,
I heard
it did, and then it was
Yeah, and I get that, and I mean, but I was present for a lot of those forums, and some of them were pretty heated, but for the most part, I thought they were handled pretty well. And as I recall, I think some of the biggest concerns in the community, and let's remember, this thing only passed, it only went down 55-45 or something in that general range, but I think a lot of that had to do with the general public and more for people on a religious basis, concerned about making accommodations for groups that perhaps they didn't agree with on a religious level. And so I think this is a completely different thing. I know that there are a lot of private businesses out there that do something similar to this. I don't know the extent to which city government employees and stuff do, but I would assume that there's a record of that out there as well. You know what? It's in front of us. I think staff has done stuff in the past to put this together. I think we could probably more than likely work towards getting this together. And frankly, I was prepared to make a motion to place this on the agenda for next week. So at least the step one that you mentioned on there, if we have to come look at a step two, we would need to come back on that. So if anybody else has that same feeling, I'm all ears.
Well, I would respectfully disagree. I think that we should postpone this as well, and I agree with the mayor's summary of the task that's on the plate for our staff. There's this commission's candle is about to burn out. We're trying to burn really bright, but there's a lot out there. To me, it's the right thing to do. I just don't think this is the right place and time. I think we're opening ourselves up to lawsuits, and we're denying the democratic process. I think if we are 5 years down the road and the public's opinion of this has changed, I think it'd be a pretty easy thing to get on the ballot. We probably should have thought about that 6 months ago, so we could be addressing it next month. But I think the public should have some thought about this. Why wouldn't the public be concerned that the cities, if their expression of interest in this is in the negative, why wouldn't they want that to apply to their own city organization? So I'm in favor of a delay and just reconsideration of this at a later time.
Do we often put city personnel manual stuff on the ballot?
No, any action directly related to the personnel manual stays with the governing body.
Okay, thank you.
But would it be unrealistic to ask the public their opinion?
Well, that's a good question. I'll be honest with you. I can't help you much from a values perspective on this. I could give you my personal opinion, but it wouldn't do you a whole lot of good.
Oh, yeah, and I don't think anybody's suggesting that you don't allow public opinion. Putting it on the public agenda is asking for public opinion. I mean, that's all I suggested with my comments is that.
To be clear, too, again, this is just because we're at a conversation stage of the topic. We haven't had time to consider the opinions of our employees either. Now, I would not want to predict because what that would be. It could be similar to the public's. It might not. I don't know. We don't have conversations about that. We haven't had reason to for some time. So I just wouldn't speculate what that is. My point is saying that is if that's important for you, we just haven't had a chance to do that. That could or doesn't have to be a step. That's up to you. That might be the group that the opinion might be of interest. But on the other hand, that can become a bit of an awkward conversation as well. I just don't know what to anticipate from that.
Do you know, in terms of accommodations, what we would, how long it would take to put together a document covering what we would need to do?
Yeah, legislatively, I don't think it's that big a deal. Legislatively, I think unless we look at and for some reason second guess what we did before, the change in the personnel manual, the language change would address that in the personnel manual from the perspective of saying, here's the rule, generally. I think even the public accommodation aspect probably can be pretty simple language as it relates to our organization. So I don't think there's much time in that. If there's time, it's more in having conversations with our employees and employee groups and discussing what does it mean. And when you have a protection like this, generally speaking, I have to look a little bit towards legal on this, but it either does or it's at least may or perceived to supersede other things. And what I mean by that is it goes back to say, okay, if we have a policy on professional dress, and if we believe that, right or wrong, dressing dressing to resemble your physiological gender is important for how you conduct your business, the policy would say, no, it's okay, someone can dress in the way they identify with, so that means that the policy would elevate over the prior approach. Now, where that line is, where the policy would overrule and where it doesn't on different aspects, I'm not entirely sure. I'd have to go back. So from an administrative perspective, we'd have a few conversations, but maybe some legal interpretation, but mostly it would be education, information, explaining this is the bathroom policy, or this is the dress policy, or this is that. I don't know that you have a lot more actions to approve those, so it's more of an implementation aspect. And to be honest with you, we've been pretty busy on all the other stuff. We haven't in any way contemplated if that's a 40-hour thing or a 3-hour thing. We honestly haven't. We just haven't gone there quite yet. So I don't want to over-dramatize it by any means either. But there is follow-up from an administrative perspective. I don't know that it would. I don't know if it would affect those other actions or not.
Are we contemplating still an agreement before the end of the year with county, or are we still iffy on that, or is there ideas
well, that's a good question for you.
Because that will be a huge job.
I don't know that I anticipate an actual formal agreement by the end of the year, but at this point, I think, and this is me interpreting your conversations, at this point, I think it's the goal of both parties is to try to find common ground that you can continue to move forward towards that. Is what I would expect would be best. Whether you'll actually have a formal agreement by the end of the year, I don't know. But that in itself, once you agree to a concept, takes quite a bit of legal work to put that together in the final form, too. So you're running out a year. I wouldn't expect you to have that. I think both parties would be happy if you just made good progress towards it.
So I'm clear, there was nothing in the public referendum that would prohibit the city from adjusting its own personnel manual in this issue?
Yeah, you have your authority. You have authority as a governing body to address the rules of your own organization.
We just prohibited from mandating it
across the
board.
Yes, across the community. That's correct.
Well, and as the person that introduced this last week, I'd just like to say that I appreciate Mayor Crawford and Commissioner Ryan's point of view. We do have a lot on our plate. But I'd also like to add that I think that we did a lot of the work on this in 2012, and I think that
yes, don't remind us we did a lot of work.
Right, and what I'd like to say is that I would just advocate that cultivating diversity and promoting inclusivity in itself becomes a continuous process improvement. And before you say what does that mean? I've been doing a lot of reading this past week with SHRM materials, and SHRM is the Society for Human Resource Management, and they're kind of the industry standard in terms of developing policy. And one of the points of emphasis that they make is that employers that are committed to a diverse work environment tend to be on the average, about 35% more efficient than organizations or companies that have a less diverse workforce. And I would just say that, in the past, since I've been on the commission, when we look at establishing other policies, we always look at industry best practices. And if the industry leader has been including sexual orientation and gender identity in its list of protected classes since 2014, I mean, we're in 2017 now, pretty soon to 2018. In 2012, when the City Commission removed these protections from the city policy after the defeat of the citywide ordinance,
we didn't all vote that way.
Right. There was discussion and dissent and confusion about whether or not the city could still include these protections in our policies. And I think we've heard today we can, and I believe that we should. And language adding protected classes affects, including seasonal help, 750 employees, as Mr. Gage pointed out. I mean, that's a huge number of people to educate and to get feedback from. I understand that. But flipping it the other way, I think it's a generally acknowledged fact that about 10% of our population is LGBT. 750 employees equates to about 75 people in our organization. This does not impose any standards on any other employer. We pride ourselves on adopting best practices, gaining efficiencies, being fair and consistent, paying living wages, and I just feel like this is an oversight in our policy, and I feel like the first step to dealing with it is to include the language, and we can walk down the public accommodation path as we need to. I think people sometimes jump to, the most extreme situations, and frankly, if you're in Salina, Kansas, I'm not sure that we're going to get presented with the same kinds of issues that you might get in a San Francisco or a Chicago or a New York. You definitely could, and we need to be prepared for that. But I feel like that we can take this first step without a lot of hesitation. So I would like to address it one way or the other, and if that looks like next week, that's fine. Heck, I'd be ready to do it today.
I didn't ask that we not address it. I asked that we delay it. That's all I asked.
Is there a way to look in to see how much work it will take without actually completing all the work? Kind of dipping your foot in the pool without getting wet.
I can list tasks, but not really, because, what we're looking at is we're looking at a change in the manual that would probably draw interest in all of our employees, I would think, one way or another, or neutral. You're going to, as you know, you'll find people on all sides, and every side sometimes to an issue. We have quite a few employees that would take some time. We have an employee council, but I think this is significant enough. We'd want to have broader conversations. That in itself could take some time to discuss with them, but and quite honestly, they wouldn't. They wouldn't have a choice in that, right, wrong, or otherwise. That's something they have to come to terms with. Is that's not, whatever would be done. In some cases, would be interpreted as helping. In some cases, would be interpreted as not something they agree with. Again, I don't know how that would be split because we haven't talked about it. I don't have any basis for that. But it certainly generates some conversations, and I think we would need to just think about how we facilitate those conversations. It'll definitely be something that gets their attention. And then, like I said, I don't want to speak for Greg, but I'd want to be clear from an application perspective and an enforcement perspective when we have this in here, what exactly does it mean? And a lot of other cities have done this. A lot of cities haven't. The ones who have, you can look at their experience a little bit and how they've applied it. But we still will rely on our own legal interpretation of, does this mean that we wish to or can or can't supersede some other approach on a particular rule that we might have. We may not run into anything. We haven't really looked at it that closely. We may run into a couple of things. I don't anticipate running into 20 things or anything like that. I don't see that being an issue. But we could have a few questions that we have to look at to see how this would apply in that circumstance. That's more for how we administer it if we get a question about administration of it, because we probably would put together some Q&A information. Now, some of that we could go back because we actually had that for the public discussions of the past, and that some of that information most of it is probably still very relevant. So we could pull that in and see what we could reuse there. But I really don't know how much time it would actually take. But I do know that I think we would owe it to the employees to give them the attention that they asked for and having the discussions and conversations.
Was their opinion vetted in 2012?
No, I don't believe so directly. We didn't. I don't recall surveying. I'll look at Mike to see if my memory's off on that. But I don't believe we directly surveyed, because at that point, and quite honestly, it's kind of an organizational role question. We don't often survey for something in which the governing body would have a direct role. So there's a question of whether we should or shouldn't survey, but we chose not to at that particular time, based mostly on a community issue more so than a local government issue.
Also, I think if you're going to survey and you're asking people what their opinion is, if you don't follow it, I seem to recall we had a employee survey that kind of showed that most employees didn't want handguns in the building.
Right.
And a couple commissioners voted they were okay with that when we sent it to the building authority. So we had a 3-2 vote on something that we sent out and got an employee survey on. So I don't think employee surveys are always the Like, because if you don't follow it, then what good is it?
Yeah, and quite honestly, from that perspective, it's a question of role. Is it a representational role, or is it a parental role? And based on what you think the outcome of a survey or the opinions might be, that could determine whether you're playing a representational role or a parental role. And then you have to decide what role you want to play as a governing body.
Well, one of the earliest lessons I learned as a parent, and I am not equating staff with children in any, but when you said parent, it made me think back. You never offer a choice that you don't want them to take or intend to follow. I mean, you offer choices where you're fine with either choice, and I think it is incumbent upon the governing body. I think one of the things we do, I mean, sometimes I know we get down in the weed and we probably drive staff crazy with some of the details, but I think that on general organizational policies and outlook, I really feel like that's where that is probably our most important role. That's just my opinion.
You're the only one here. Why don't you come on up?
Well, I don't have much to say, but,
Name.
Gary Martin's,
Yes,
Gary Martin's, 821 Highland Avenue. The thing is, in 2012, this was in effect for 6 months, give or take. So it was in operation. It was going on, and somehow the city managed to handle that. And somehow they managed to handle it with their employees and that type of thing. So to me, rehashing it seems on these grounds of, how are we going to handle it? You handled it. It was there. It was done. And you have the opportunity to do something that's right and something that's good. And personally, when you talk about doing this employee survey to see if it's okay to bully me as a gay man, if I was an employee here, I find that offensive. To find out, ask a public, your employees, if it's okay that they're going to not give me a promotion or not treat me equal if I was an employee here, that's offensive. You're going to leave it to people to say, it's okay to bully Gary? That's wrong. So, and again, it was in place, it was there for 6 months, and it operated. And those questions have all been hashed and rehashed. So, you can carry it on and carry it out, but it's been done, and it worked just fine. Thank you.
Thank you, Gary. Well, he has a point there, because of course, I'm kind of foggy on what happened way back then, but he has a point in the fact that it was in effect, as I recall. And I don't remember whether we had a lot of visiting about that, because all I was thinking about the time, and I think what we voted on at the time, was Chapter 13.
Yeah, that's
Human
correct.
Relations Ordinance.
We didn't have an employee issue because the amendment was to Chapter 13, and Chapter 13 applied across not just our organization, but most all private businesses and other organizations in your whole community, where we chose to add that and regulate that activity or that protection, to add that to our list of protections and then regulate that in our community. So there really wasn't an arena for, I say that, the arena was the same as for the public when we had the conversations and the forums over at the community theater, which I thought worked really well for the conversation. There were some certain employees that did have a perspective, and they showed up. So they had the same opportunity there because it was a community topic that anybody would have. And that's a right that an employee has, and a legal right. I'd have to defer to or the city attorney with regards to that when you're dealing specifically with the organization in a hierarchical fashion, whether they would or not. But at that point, it was done. It was over with. There wasn't anything left from the talk about. And I'm not saying it's right or wrong. I'm just saying that was the fact.
But it was pretty well dispersed to the public and to employees and everyone at that time through those workshops that Gina had, as I recall.
Yeah. So, they had those same opportunities.
Because there was a lot of people there.
Yeah, but and so the other side is, were there employees, unbeknownst to me, that were party to signing the petition, or how did those employees vote? I had no idea. We don't ask them because it's not any of my business. So I don't ask them that. So I have no idea where they stood on the issue and what role they took in those, whether it be through a petition or also just through the voting. I have no idea.
I have a technical question, and it has to deal with looking back to the 2012 action. Outside of, I'm assuming that some of the other housekeeping measures in this resolution, such as changing pay periods and anniversary dates and all those things, that really hours of work and overtime, all of those except for the equal opportunity and Article 4 and 5. Article 4 and 5 are the only sections that basically probably haven't already been updated in some fashion since this was you know what I mean?
Yeah, I'd say that's true.
Taken out. I would assume that at the time that this was done, that some of those other, since it was prior to a definition being changed and all that, there were going to need to be things updated and done in the process of, this wasn't going to be the last step in this whole process in 2012. You still would have probably had to figure out the accommodations and
sure.
and all those.
Yeah.
But my question would be this: what would be the harm? And I would think it'd be very little staff time to place this as it was without the other amendments to the policy, to the employee manual, on the agenda next week, and just do the 4 and 5 the way it was without everything else, and then we take those next steps as we need to, which would, in essence, the date of this was December 17, 2012. It would basically put us in the same exact place as December 17, 2012. Am I reading something? Am I missing something out of that, or is that pretty?
No,
that'd be pretty much where we would be.
I think it would. I think this is going to be a little bit different, and it's going to be different probably because of the context not being community-wide and simply conforming with that versus just saying that's for organization. So I anticipate that'll draw interest and conversation. But so I'm not probably the right person to ask what would be the harm. That's a value judgment, and I don't want to speak because that's something I can't speak on behalf of our employees.
I'm not talking political harm. I mean, that's why we're here.
Yeah.
That's not for you, but I'm saying.
Sure.
What I'm saying is that this was in place. This had to be repealed.
Yes.
The action repealed this. This was in place, and so. My question would be, everybody was aware of this and I don't know the 6 months or whatever I'll just go with that because I don't know any better than that. But I'm just saying, this was repealed, and because all of these were in place, and like I said, I think vacation, sick leave, all those things subsequently got placed back in, and just 4 and 5 haven't. So I guess. My word of what's the harm really wasn't that, but I guess what I'm getting at is what really is the staff time constraint to get us to where we were before we repealed this?
We can draw this up as a personnel, for a resolution to update the personnel manual in no time at all.
Okay.
That's why I say the legislative part really doesn't take any time on that piece. That's very, very easy.
Because all you do by say, well, let's don't do it, is saying I don't want to deal with this or just delay it. I mean, if it's not going to take really any staff time.
That part won't take any staff time. What'll take staff time would be the follow-up conversations with the employees and listening to those who thank us and listening to those who don't like it and didn't want to see it happen, and trying to answer those questions and try to just deal with that aspect of it, because it is a right, wrong, or otherwise, it's a pretty significant change. It's not a small item in the personnel manual. So there will be a lot of conversations once it's approved, and we'll just need to have those.
Although, I think the conversation with them needs to be with whether they don't like the adjustment to the personnel manual. They don't like a person like that working with them, because those are two different things. All this is saying, if that's the best person for that particular job, however diverse they are, then that person is an asset to our organization. All we're saying is you can't bully this person for that reason.
Right. They can't bully
They
that
don't take a
person
vote
today.
on any other person who's being
Yeah.
hired.
They can't
Keep
bully
in
a person
mind,
today.
keep in mind, there's no, when you look at our personnel manual and you look at the, that basically language that deals with how employees are supposed to work together, you're not going to see an exception for this. So today, all you have to do is read the manual directly on the bullying topic. There's other topics, and I get that. But on the bullying topic, that's not accepted today, and that's based on a true interpretation of the manual.
And bullying taking many forms. But this is saying this would be an accepting environment for, there are other differences in outward appearance that many of us find even more potentially offensive than one's sexual orientation. We're all full of prejudices, likes and dislikes, but this is just to offer some civility.
Right.
And I don't think we look like the leaders we're supposed to be, or the parents we're supposed to be, when you look at the conversations the high school students are trying to have. If we keep dodging issues, they go deeper and deeper and deeper. And it's not to say that I'm necessarily advancing one lifestyle or another. It's not about that. But this is a country based on tolerance. And until something in this country is illegal, it's assumed that we are tolerant of. At least that's the approach I take.
Yeah, let me just cut to the quick. Let's make it easy. Okay, you're likely to have a majority of our employees that would not have any desire to cause harm to anyone who simply disagrees with the value judgment, right? Both sides to this, like many other value issues, believe their value, their place and their value is correct. Okay, so the point of it is that in this likelihood, in this situation, you're likely to have a majority of folks that this affects that says this is a bad idea. And you should expect that, because you see that, you're going to see that with even a 55-45 in the community. It may reflect that, it may be different, I don't know, but you still see that. Now, that doesn't mean that you should or shouldn't do that. What I'm saying, though, is as it relates to the time that we have, we're going to go back and have conversations with a lot of people who believe that you've forced a value judgment on them that you shouldn't have, because their values are different, and they don't believe that their values are bad, and they don't believe that their values would cause them to harm anybody. So it's not about, I can't say entirely it's not about harm, because I don't follow every employee everywhere across the organization, okay? But what I will say is when we categorize someone who disagrees as being harmful, they would look at that as unfair, and I would agree with them. So we're going to run into those perspectives, and it's my job then to have that conversation. The easiest way to deal with it is just to simply say, sorry, we're not going to engage you, except to tell you this is the new rule, this is what we're going to do, this is how we're going to do it, you need to get over it and move on, and we'll try to be nice in how we do that along the way. But that doesn't usually sit well with adults, because we should engage them in a different way than that. But it's going to be a very difficult conversation. That's what's going to take time. It's about the time, and that's what will take the time, not the legislative part. It's about having those conversations. And I like to think I'm pretty persuasive, but I'm not sure I'm going to be able to convince someone to change their value place. They're just going to have to listen and accept it and move on.
And in that regard, the accommodations issue would have to be addressed at the same time? I mean, before the policy was rolled out?
Well, I personally, I think that as you look at it from a business perspective and you're dealing with the employee piece, one of the issues you're going to be dealing with would be the restrooms, without question. And so you're already dealing with that. If you believe in what you're doing, you should apply it to the degree that it makes sense to apply it in your organization. You don't cut it off here or cut it off there. It's all one piece. It's about public accommodation and employees. So you'd come back with that. Now, I could be wrong. I'm speaking for Greg a little bit, and he might have a thought on this. I really don't think that that's that difficult either as it relates to our organization. I think that we could probably draw that up pretty soon. I don't know if we can do it in a week. It might take, because we're working on other things, it might take a couple of weeks, but I don't really think that that part is that difficult. For us, the difficulty, again, is going to be having those conversations and just simply being clear in our interpretation and communicating that. And like I said, much of that information we'll be able to work from the past community conversation, which in that case, that's helpful because it's already there. We did a lot of work on that at that point in time. But we'll run into some other scenario questions we may not have dealt with then, and we'll put that together and we'll get that out to our employees. But that's where the time's taken.
Do we still have that information from some of those
Oh, I'm sure I do.
workshops? And
I'll cut to the chase too. And because I appreciate you saying, you know what, you probably can't do it in a week, but probably two. And so, Mr. Bengtson, as our parliamentarian, if I wish to make a motion to have this item placed on the agenda, does it have to be at the next regular meeting, or can I set it for a date certain?
I believe you could certainly move to set it for a date certain.
Okay, so if I were to make a motion to place this item on the agenda for consideration on the October 22nd?
I think it's actually the 23rd, but I don't believe there's a meeting scheduled,
We don't have a meeting on the 22nd?
or the 23rd, Monday.
I mean,
Aren't you guys going to?
I'm sorry,
What's the
Excuse me,
23rd?
CMA.
Yeah, I have the 23rd on, what,
Okay, okay. So
Well,
the
and
30th?
whether, well,
No meeting.
yeah.
I'm not trying to influence that question of whether you're meeting or not. I just happen to know at this point
Okay.
in time, there's not one scheduled.
Mike and I will not be available on the 23rd. The 30th is a fifth Monday.
Right.
Now, you could, if you wanted to, you could have a special meeting. That's more about scheduling the five of you. If you really wanted to do that, that's not a big deal from our perspective.
I'm just interested in having a date. So if that's November 5th,
Yeah, 6th. Unless you want a special meeting on the Sunday.
somehow I'm trying to get our meetings on Sundays,
Yeah.
you know?
Well, you'll fill up the seat.
Well, the 6th is on a Monday.
November, so if it's on, well, I'll tell you what, unless someone else has got anything else, I'll just make a motion that we place this item on the agenda for consideration at our Monday, November 6th.
Is the 6th the employee breakfast, is that
No, that's the
That's the
7th.
7th.
7th?
Yeah. Commissioner, for clarity of the motion, when you say this item, are you referring to both an update to the personnel manual affecting employees and an action to address the public accommodation?
If you are, will that give you enough time to do both of those? Because that may be
Yeah, I
to the
think so, and
benefit.
if you're forgiving of us, if we run into some reason that we can't, we'll let you know ahead of time, and then you can whatever time frame after
take a
that, you
piece,
could.
take a piece of it?
Sure.
Okay. I don't know. So that would, the motion would be to place the consideration of the employee manual and accommodations at the November 6th, 2017 regular meeting.
Second.
Okay, I have a motion and a second to place the item, equal opportunity items, what I call it, sexual and other workplace harassment, addition to or sexual orientation and gender identity, I guess it is, on the calendar for November 6th. Is that what you said?
Yeah.
Is there any discussion? Will just the question I have, is that going to give staff a little bit of breathing room to get some of the items that I talked about pushed forward and not?
Well, like I said, from the legislative perspective, I don't really expect it to take too long. And on the public accommodation issue, as I mentioned, I'm speaking a little bit on behalf of our legal counsel. So I think that still will be fairly easy. If we run into issues, we'll let you know on that. Our time is going to be spent from that point immediately after that, addressing employee questions. We'll have to think about how we want to do that, or we're going to deal with go department to department or what have you. But that's what we'll be spending time on afterwards.
Okay. And sometime, we haven't set a time for, and I don't think the county has, for the Kenwood Park.
The next joint
next-
meeting? Yeah,
I think they suggested sometime before Thanksgiving, and that's why all these things
Yeah.
seem to be coming together.
And ideally on that, I think we should be prepared and would like to meet early November if we can. I think we probably can do that, not push it too close to Thanksgiving.
Yes, put one more fly in the ointment. As far as accommodations are concerned, since the entire building is not city, would any action we take apply to only whatever part of the building that you consider yours?
Right.
Or
If we're talking about restrooms, you're correct in that the city is basically a tenant. The building authority, board of directors manages the policies. So if you would want policies regarding, well, if you would want this approved and applied in this building from the perspective of the public accommodations and the restrooms, as it relates to employees, you'd have to go to the building authority and have the votes to get them to update their policy. With respect to just our employees, other than the restrooms, it's an organizational thing.
Right.
Okay. I have a motion and a second. Any other discussion? All those in favor say aye. Aye. Opposed, same sign.
No.
Okay, one opposed, passed. We're down to item 7.6.
Item 7.6, resolution number 17-7481, formally adopting the amended City of Salina municipal naming guidelines.
Okay, Mayor, Commissioners, you gave us some direction after a couple of meetings ago on this, and we went back and updated. And let's see here. Look here, I'm going to skip you into this pretty quickly because there's no reason to go back through the whole thing since you already did that 2 meetings ago. I imagine you probably want to get home. But we made the changes as it related. We eliminated the minimum percentage or any dollar amount for purposes of the whole naming. I made modifications to the definition that dealt with a public facility to make sure it's broad enough that you could pretty much put that on anything but a roadway. We look at roadways a little bit differently because of addressing and so forth. So I think we have made the changes that you'd asked for. Let's see. Those were the main things, actually. Oh, the other big thing was the addition of commercial naming category to differentiate that from the philanthropic, where both would kind of fall into philanthropic before. So those were the 3 main changes: the commercial category, the elimination of the addition, I should say, of the minimum amount for the whole facility naming, and then making sure the definition of the public facility is broad enough. So we've got them all in there, and I think we addressed everything you asked for.
just on the commercial naming, would that then be a contractual arrangement similar to what happened at the former Bicentennial Center?
It could be. The naming policy leaves open the time frame, and so you have the ability to control the time frame for the naming in any way you want. So it could relate to an agreement. It doesn't have to, but it could. I mean, you have the authority to set the naming. If it's naming for certain dollars, you have the ability to require an agreement. You don't need to. You would need to put that in here to do that. That's just a reserved right. If you say, well, we'll do it, but here are the conditions, and you want to put those into an agreement, you could certainly do that. So I could see it working like that, or I could see it working in the same way that you've handled the naming before. It's really up to you, but certainly in certain circumstances, an agreement might be in order.
I appreciate the changes. I think you did a nice job on that.
Thank you.
Mm-hmm.
I think it'll make things a lot easier down the road, especially if there's adding that commercial category.
Yeah, I think so. And in going back, again, not anticipating the broader base thing, I think it very clearly says if you're going to go through a broader base attempt, because it's really, you don't know at the time how successful you're going to be. So if you're going to attempt to go and solicit donations from a broad base for renaming, naming the parts or all of a building, it says get your plan put together. Presuming that the building's eligible for naming, bring it in, have you approve it, and then you can say, go ye therefore, and work as hard as you can to get it. And I actually anticipate that being used potentially as you move forward with the river project. I think there are going to be aspects of that where naming could actually make sense and generate some additional private dollars for the project, and this would work really well for that. So appreciate it.
Some of us remember not just the last few, but I was thinking of the stage over in Oakdale Park and all that. And good Lord, I mean, if this will help.
That was the reason.
Better.
Yeah, that was what prompted the policy. So, makes sense, right?
It elicited a good Lord. That's enough.
Okay. I'll bring it back to the commission for action unless there's some discussion. Any more discussion?
Yeah, I'd move passage of resolution 17-7481, formally adopting and amending the city of Salina municipal facilities naming guidelines.
Second.
Okay, I have a motion and a second to approve Resolution 177481. All those in favor say aye. Aye. Opposed, same sign. Okay. Guess we're down to other business, and police chief isn't here, but you can pass this on to him. I thought that his commission information memorandum was just excellent. We get these every so often, and for the public that might be listening, it's just a way that department heads can tell the commission what they've been doing and what the good things they've been doing. And I thought his was excellent. He included a letter from Central Kansas Mental Health Center in all the work done by the Detective Mangles and his work with our crisis team, the Central Kansas Mental Health Crisis Team. And I think that's so important, especially these days. Also, he included some information from the United States Postal Service, where the police officers have been commended by the Inspector General of the United States Post Office for their gratitude and giving gratitude to the Salina Police Department, and listed the names of the officers, and I'm going to name those officers. Officer Dave Villanueva, Detective Crystal Hornseth, Detective Lane Mangles, Sergeant James Feldman, Detective Matt Halton, Detective Rachel Larson, Detective Crystal Marks, Detective Tim Hosley, Detective Amanda, I believe it's Amanda Ladondo, and Detective Chris Venables. Anyway, I think that tells a lot about the officers we have working for the city of Salina. And I just think that the commission information that he gave us this week was especially well done. And I wanted to thank those officers at Salina Police Department. Okay, anything else?
That was nice, thank you.
Just two little ones.
Okay.
I almost went past the road to the airport this morning because I was giving my wife directions. I thought I knew where to turn. I took my eye off, and she started to go past the street, and I said, right there. She said, there's no sign. And there really is a little tiny sign that blends in with a green background. But the signage in that entire airport industrial park probably could be updated. I've been to 6 airport authority meetings, and I've only not got lost once. Thank God for the Jake Sharp sign. And I've learned how to look for that great big black and white sign. But those street signs are, as I'm getting older, harder to read. If we could get something a little more pizzazz, and particularly for the airport, because there's literally one sign now. It seemed like there used to be more, but there's just one side south of Magnolia that even lets you know there's an airport back there.
Yeah, we recently have talked about our wayfinding, especially on that main corridor out there. So that would fit right into that conversation. And quite honestly, I agree with you, because that's sort of on a curve, and once you get past it, you realize that you missed it, but you're up on it. It's just sort of a different visually as well. So yeah, we'll make sure and take a look and make sure that whatever we're talking about, we're making sure that people can go to the airport.
Right. And I did have an opportunity to play on the courts at the Fieldhouse 2 weeks ago, and have physically recovered since then, so I'm ready to go again now. I noticed on the inside wall there's some pictures of what the block used to look like, and I guess from a historical perspective, they're nice. Someone who did not know what was there might wonder, well, why are these pictures there? But what I think is still missing is whatever plaque we're going to put up to commemorate the financial contributions from the taxpayers of Salina, and I guess if new market tax credits or federal tax credits, in a way, the federal government, whoever we get those from. But
I didn't promise the federal government any recognition.
Well, in that case, the citizens of the, and we paid those taxes. Right, we've already paid those taxes.
Yeah.
But I think there should be some acknowledgement, and
they haven't forgotten. They're working on that. That right now, they're just still wanting to finish out with the construction list of items. But I've talked with our Parks and Rec director recently on that, and that is on their list to get to. But we've got to continue working with our contractor to get some other stuff finished up that should already have been done.
And want to make sure that certainly our two commissioners who know for sure they're not going to be back here next year are recognizing. And usually the sitting mayor, when a building is open, gets the credit, even though that person is merely, worked on the shoulders of those who did all the heavy lifting. But, and, at anyone else's discretion, perhaps even list all the commissioners since the inception of this who have worked to push this through. Because the city commission and staff and the citizens have put a lot of hard work into getting that building up. Which really is very nice on the inside. So far, I haven't had to stand in line at the men's room, but it's a really nice floor. But don't wear new tennis shoes until that floor gets smoothed out a little bit, get a little bit too much traction there. But it's a great facility.
And just to kind of piggyback on that, the Smoky Hill Museum has a nice dedication plaque inside the front door that also recognizes, I'm fairly certain, the city manager at the time and some other city staff, and I think that would definitely be something that we needed to include on that plaque as well.
And the deputy city manager and the city
definitely
city attorney.
Yes, yes.
And you want to be on it?
Parks and Recreation Director. Yeah.
We'll probably hurt our shoulders from patting ourselves on the back too much if we're not careful.
I have two quick little things. First of all, just a real big thank you and appreciation for Jim Kowach and Jim Toich, who both participated in the fall fix-up, both in town and a little bit out of town at the landfill. And then also a big thank you to the crew that you have out there at the landfill. Mm-hmm. That they were there the extra hours. They were all working hard, and those are just great guys. It's a, I think everybody knows. I think Jason, you talk about how they really embrace the CPI, and they really care about excellence, and they, I think, have a great work ethic, and they're just good people out there. So I appreciate all of you out there doing that. And then I also want to welcome Ms. Driscoll, our new Development Services Director. And it's great to have you here.
Okay, is there a motion to adjourn?
Yes, ma'am.
Second.
So moved, I think you said.
Yes.
All those in favor say aye. We are adjourned.
Aye.
Aye.